But we want to break down now the charges and what they mean for the president's reelection campaign. So we will want to bring in now former federal prosecutor David Weinstein. He joins us now. David, we know that former President Donald Trump is expected to head to New Jersey, where he's expected to have a huge campaign rally, and we can only imagine that this will energize his base and his supporters.
Well, that's true. That's presuming that he's allowed to walk out of the courtroom, and I don't see any reason why they're not going to release him on conditions of bond. Remember, every defendant who makes an initial appearance, the government in all cases usually seeks what's called pretrial detention, either because you're a risk of flight or a danger to the community. Here, we've seen that he's been released on a bond up in his case in New York. Everybody knows where he's going to be and what he's going to do. It's what he says that's potentially dangerous to the community, but he'll get out on a bond. Question for me is, will he, like every defendant, both those who I've prosecuted and represented, have to surrender his passport, have his travel restricted, report to the pretrial services on a weekly, daily, monthly basis? But presuming he gets out and they agree on some sort of signature bond, he'll be campaigning around the country. I think that the judge who controls this case may enter an order restricting what he can and can't say, but in terms of his reelection campaign, it'll sort of proceed as it had all the time until he's convicted of a disqualifying offense and then elected to the office. He can continue to campaign, so that's not really going to change.
And David, as he continues to campaign, we've heard oftentimes a reference that things move very swiftly in South Florida federal court, but that may not be the case. There's also a rhetoric that the perception that Trump is going to fight every single step, tooth and nail, and essentially drag this out as long as potentially possible. What's your perspective on that?
So he is absolutely going to do that. That's been his pattern and practice in any litigation he's been involved in. Remember, in a criminal case, you have this 75-day speedy trial clock that starts ticking as soon as you're arraigned. Now, it can be told, meaning stopped and put on pause, by the judge who presides over the case for a good cause that's shown, and that is because the defense needs more time to prepare or the volume of documents is too great. It also is going to get told when they file motions to suppress, motions to dismiss, and those types of motion, which are going to potentially either keep evidence out of the trial or delay the proceedings because of the allegations that are made, those potentially are going to go up to the 11th Circuit Court of Appeals. So then they're going to get briefed up there, and the speedy trial clock is going to continue to be told. And so while a routine case, and even a case involving a large number of documents like this, is somewhat routine here in South Florida, it could be resolved in 6 to 9 months if everything clicked along as we expected it would. But in this one, I think we're going to see a lot of pretrial delay. You also have to factor in the fact that because these charges relate to the unlawful retention of classified documents, defense documents, the defense team is going to have to be cleared to look at these documents. That means they're going to have a background check. And then they're going to have to set up a secure location somewhere for the defense to review these documents and to go over them. That's part of getting ready for this trial. So in a very long-winded way, what I'm telling you is that it's not going to be as quick as a normal case, and I wouldn't be surprised if we don't get an actual trial setting until into mid-next year. Most federal district court judges want to move their docket along, and we'll keep an eye on the parties, but this is a case unlike we've ever seen before, even given the high-profile cases down here. So this is, in fact, going to drag out well into 24 and probably come close to election time.
And I want to speak to that. First, I want to get in that we do have some breaking news. The U.S. Marshal just confirming with CBS News Miami that Trump has been processed. But just to your last point, what happens, it's the big question, if this does go into elections? Because we know that right now Trump is the Republican frontrunner.
Well, we'll have to see if he ends up being the Republican nominee, and if that's the case, this is going to be hanging over his head as he campaigns. I'm sure there'll be a lot talked about it during the course of the campaigns. But again, remember, any defendant is presumed innocent until proven guilty, and there's nothing that prevents someone who doesn't have a disqualifying felony offense for continuing to run for office. And so it is going to linger both in the background and in the foreground, and it will be something that's continued to be talked about. But until there's a conviction, and one that's upheld on appeal, He's not a convicted felon. He's charged with some very serious felonies, and there's a lot of factual support for the charges that are contained in the indictment, but until he's convicted, it's campaigning as usual.
And David, just as a point of clarity, if he is convicted of violating the Espionage Act, would that be a disqualifying offense?
Well, there are certain portions of the Espionage Act that specifically contain a clause that says if you are convicted under this subsection, you are ineligible to hold office. The charges that were filed in this indictment, none of them contain that language. So we then are going to get into constitutional interpretation. Well, what does the Constitution say about which felony disqualifies you from holding an office? When is it final? But again, it would seem to me that he is going to be, if convicted and if the conviction is upheld on appeal, he is going to be convicted of a felony which is going to strip him of his civil rights. Now, those include the right to vote, the right to serve on a jury, the right to possess a firearm. There's going to be a lot of litigation about whether those also include the right to hold a public office.
And when we talk about this particular case, I mean, there's not really a precedent for this. So its implications are so significant because it also lays the groundwork for future incidents like this.
Well, there are other cases like this that have been filed throughout the country. Several months ago, Jack Teixeira was arrested. He's the former Massachusetts National Guardsman for having access to classified documents, taking classified documents from a place where they were kept securely, removing and possessing them, and then distributing them. Now, he hasn't even been indicted yet. I suspect they're trying to settle his charges out with a resolved plea agreement. There have been a number of other cases where former federal officers, FBI agents, federal officials have all been charged with the unlawful removal and retention of classified documents. So on that side of things, I think there's plenty of precedent about what happens to people who have been convicted. The thing that's so unusual about this is that we're talking about the former president of the United States who unlawfully removed and retained these records. And so that's what makes this such an unusual and unique type of case.
Yeah, and just to clarify, that was my follow-up with you. There is no precedent for a former president of the United States. This is United States history happening in real time. And speaking to that, Jim DeFede, I think you wanted to interject.
Yeah. David, I just want to ask you a question. A couple of things. You know, you talk about speedy trial. It's interesting how this will unfold. It is not in the president's interest to exert a speedy trial. You know, I could see him wanting to drag this out and delay this until after the election to sort of see how this plays. But assuming when we do finally get to the stage of a trial taking place, I'm curious, do you think that the trial will take place in Miami or in West Palm Beach at the federal courthouse there, since that's really the county in which the conduct was conducted? And so usually federal trials try to get as close to home as possible. But I would imagine Miami, in many ways, the Miami federal courthouse is better suited for a high-profile case like this. Any thoughts?
You're absolutely right about that, Jim. Look, this case should take place in the West Palm Beach courthouse. That's the box that was checked on the certificate of trial attorney. That's where the case was filed. I know it landed in front of Judge Cannon, who sits in Fort Pierce. But this is a case that should be tried in West Palm. They should draw a jury pool from West Palm, and everybody should show up to the courthouse in West Palm to start picking a jury and trying this case. The reality is, it's a small, older courthouse. I don't know if they're equipped up there to handle the sheer volume of both attention, security, the number of jurors that are going to have to come through there. So then that raises an even bigger question. If I'm the defendant in this case, I'm going to demand that the veneer, the jury pool, be drawn from West Palm Beach and the area that services that courthouse. I don't want to have the case in Miami and have jurors brought from Miami. That's not the venue where this occurred. That's why this case was filed in West Palm. That's why it ended up in front of Judge Cannon. So how are they going to get that jury pool down here? Are they going to put them on the Bright Line every day and bring them down? Are they going to truck them down in vans? It's going to create some serious logistics. Now, granted, if I'm the prosecution, I'm going to argue the case was filed in the Southern District of Florida. That stretches from Key West to Fort Pierce. And so the veneer or the jury pool should be drawn from the people who are in the Southern District of Florida. We can't possibly try this case in West Palm, so we're going to have to try it, you know, down here in Miami. I've been involved in cases both as a prosecutor and a defense attorney, where the case was filed in, let's say, for example, Miami. It got transferred to a judge in Fort Lauderdale, and that's where we picked the jury. That's where we tried the case, vice versa. Case was filed in front of a judge who was sitting in Fort Lauderdale. That judge then transferred down to Miami, and the case came here. It wasn't a high-profile case, and I wasn't fighting tooth and nail about where the veneer should come from, but you're right, Jim. This is a West Palm case. The jurors should come from West Palm, and the case should be tried in West Palm.